buongiorno tutti, good afternoon to everyone. Welcome to the webinar on international arbitration and COVID-19, namely practices of Istanbul Arbitration Center, ICC and Milan Chamber of Arbitration. First of all, I would like to thank my friend Yasin Ekmen from ISTAC and Professor AKINCI for their effort and energy for preparation of this webinar. As well as I would like to thank my friends and very valued professors from Italy, Giacomo Rojas ELGUETA and Professor Maria Beatrice DELI for their preparation and contribution to this program. We are very happy with the interest to this webinar because as soon as we launched the program, we received many registrations from different countries, almost 15 different countries, with a very international attention to the program. From Canada, from US, from Qatar, Switzerland, Germany. I don't remember now the countries, but it is a success of, first of all, ISTAC, second of all, D&R Law Firm, and third of all, my association, ILIDA. At this point, I would like to briefly introduce ILIDA and myself to enlighten the people what we are doing and who we are. My name is Arzu Ongur, and I am the President of International Law Investment and Development Association, as well as the Managing Partner of Ongur and Partners Law Firm. And we have been practicing international law arbitration and litigation for more than almost 15 years to 40 different countries, over 1,000 clients, which means that we have quite enough practical information about this, about international law. So during all our practices, we realized that there is a lacking NGO, and accordingly in 2018, we set up an NGO, ILIDA. So during the registration of this webinar, we received many questions about ILIDA. Just visit our website and we will be very happy to answer your questions and seeing you with our programs. What I want to say now, today we will deal with three important international arbitration institutions. First of all, Professor AKINCI will explain us the position of ISTAC during the COVID-19 pandemic. Second of all, Professor Maria Beatrice DELI will explain us the position of ICC during the COVID-19 pandemic. And third of all, Professor Giacomo Rojas ELGUETA will deal with practices of Milan Chamber of Arbitration. We are very proud of hosting these three important leading professors in our program. And at the beginning of each presentation, I will deal with very briefly about institutions and our speakers. First of all, I would like to start with Istanbul Arbitration Center. Istanbul Arbitration Center set up in 2015, and considering their new establishment, they are doing very impressive work in the international scheme. Indeed, even my law firm, we are very frequently referring the ISTAC rules because especially with the international clients who are doing cross-border transactions from Turkey or to Turkey, they was looking for a credible, transparent, and cost-efficient mechanism. And since 2015, we are referring very frequently ISTAC rules. Indeed, with two important projects, one of them was the pipeline project from Turkey to Cyprus. I was negotiating with all parties of that project, and the foreign parties was so happy to put ISTAC rules in the contract. There is no dispute yet, but in the case of any dispute, we would be very happy to carry out arbitration procedures before ISTAC. In the meantime, with a second project, renovation of aviation systems of 18 airports in Turkey, we put ISTAC rules again, and it was a great success for Turkey and for also all the parties of the project. And we hope the attention of the international community will increase in favor of ISTAC, and we will be very happy to support also in terms of activities of ISTAC. Well, as a practitioner, three important measures was essential during convincing the parties to put ISTAC rules. The first one was the location, because everybody knows that Istanbul is a great location to carry out an international arbitration proceeding. Second, the enforcement of ISTAC awards was great opportunity and great measure for all parties. And third, cost efficiency was an important element for the choosing ISTAC rules. Well, I don't want to spend so much time whenever we have the president of ISTAC here. And now I would like to put stage to Professor AKINCI, and he will present us the practices of COVID-19, practices of ISTAC during the COVID-19 in next 20 minutes. Stage is for Professor AKINCI.
Thank you very much. Thank you, Arzana, for your very kind words, for your very tough efforts to support ISTAC, and also organizing this webinar that I am very happy to participate. And I am also very happy to observe that things are getting much better in Italy, to see the colleagues, esteemed colleagues, and to participate in this conference. I mean, one of the bright point of this pandemic, if there is any, it changed our life, it changed the method of getting together. So it is very easy, very practical to organize this kind of things. And I think this is another good opportunity to be together, to exchange opinions and to update each other about the developments during the pandemic time. Taking this opportunity, I just would like to give a very short introduction. In fact, Arzu Hanım already did much better than me by saying that in very important, very giant projects, already ISTAC arbitration clause was referred. The Istanbul Arbitration Center was designed for international disputes as well as domestic disputes. We have in Istanbul Arbitration Center international board for international disputes, and this board deals with the cases that has foreign elements for the international disputes. And in international board, we have very eminent, very well-known practitioners. I'm sure you all know all of them: Professor Jan Paulson, Bernard Hanozio, Dr. Hamid Karavi. They very kindly supported Istanbul Arbitration Center since it was set up, and we are very proud and lucky to have them in the board. And in our international board, the majority consists of the non-Turkish members. So that means the international board is truly international. And the board, in any case, is the most important organ for an international arbitration institute, because the board appoints the arbitrators, decide on the challenges, and apply the rules whenever necessary. One more point about arbitration law in Turkey that is very short, because Turkey is one of the ancestral model law countries. So therefore, if any international practitioners have arbitration in Turkey, he or she would feel at home, because we are ancestral model law country, and you all are very familiar with the ancestral model law. So nothing would be surprising for you. In addition to this, Turkish law allows the parties, if it is international dispute, to exclude the jurisdiction of Turkish courts to set aside the award. So that means the parties may agree, saying that we don't want Turkish courts to set aside arbitral award, so there is not going to be an application to the Turkish court. This is also a lot in Turkish law. Now, talking about pandemic period, this has been a very challenging period. And in Turkey, the Judicial Institute, the courts, suspend the operation. But in Istanbul Arbitration Center, we did not stop. The cases continued, and we accepted to have the new cases. During this challenging period, we received a number of cases just started. So Istanbul Arbitration Center has not stopped the operation. Having said this, we also approached the tribunals and parties if they wanted to suspend the arbitration. We consulted them and we enlightened them about suspension, because at the end of the day, it is a very challenging time. Everybody's priorities has changed, and it is quite understandable if any of the colleagues, either attorney or the arbitrators or the parties, would like to stop arbitration. So if this is the case, we said we can support you. It is very understandable. I would like to inform you that only one arbitration case decided together with the parties, the council and arbitrators, to suspend arbitration. And we understood it, and then we said, okay, we can extend your time. But apart from this, all the cases continued, and there was no suspension decision. For the cases that continue during this challenging period, of course, there were two important points. First, being in the office. Administratively, we had someone in charge to check the mailing. So therefore, there was no problem with the hard copy issues, but the parties and arbitrators have been very understanding during this period, and exchange of the submissions were conducted through emails or in electronic way. So therefore, there wasn't any problem at all. Another issue was, of course, the hearings and the meetings with the arbitrators and the parties. Again, this was an interesting experience for us, because all the hearings supposed to be or preferred to be online. Immediately, we set up online hearing rules for ISTAC cases, and it has been very practical for the parties and the arbitrators, because some of them did not have any experience at all, forget the hearing, any professional meetings. So our rules guided the parties and the arbitrators from starting the organization of the online hearing until the end. Of course, the bottom line is the right of hearing. The right of defense is very, very important. Therefore, in many articles, in many provisions, we stress that whatever even the parties agree, it has to be, the right of hearing needs to be respected. So this is very, very important. And in every provision, we decided to ensure that the parties' right of hearings is expected. And also we give the authority under any circumstances, if the arbitrators feel that the right of the hearings is somehow not ensured, violated, the arbitrator has the authority to stop the hearing, not continue, because the right of hearing cannot be ensured. So I don't want to give the details, all the provisions, etc., but this is the idea. And since then, I think the day before yesterday, we had the latest hearing. After each hearing, and because of the curiosity, I have to say, we would like to get the feedback from the parties if there is, and if there was anything wrong, any complaint, how did it go, etc. And all of them were surprised. That was their first impression. And they said nothing went wrong and it was very convenient. And some of the hearings In some of the hearings, some of the parties participated from abroad. And again, that was also a little bit challenging for us. We were very curious about it. We said, oh, how was it to get a non-Turkey resident party's impression? And they were extremely surprised because practically they cannot travel. But at the end of the day, the hearing conducted successfully. At least there was no complaint, but on the contrary, they complimented that this online hearing worked. Of course, this is an academic and practical dispute. If the physical meeting is available, should the practitioners prefer online hearing, or if there was a physical hearing, would it be different? This is something else. I mean, we all practice, and especially when you conduct the cross-examination, looking at the eyes, looking at the mimics of the parties, etc. Each of them very important, and you cannot ignore them. This is not in dispute, of course, but in this challenging period, I think our humble experience is online hearings are doable. Comparing to physical hearing is one thing, but we can say for the due process, for the right of hearing, at least our humble experience, it is doable, and we did not get any complaint, any resistance, etc. And at the end of the day, all the participants were very positive, and they expressed that they were happy with the proceeding. There is another issue that is cybersecurity. Well, this is important, but sometimes it is exaggerated, I have to say. Of course, the confidentiality is very important. And one of the issues that parties may prefer arbitration, or maybe the confidentiality. It is, without saying, confidentiality is one of the focus for each arbitration institute and arbitrator. But the security, even for the physical hearings, is an issue. I mean, if there is going to be an attack, it can be anyhow. So therefore, saying that, oh, okay, I found something that is 100% secure is really very, very difficult. We need to be realistic. Many times they ask me, oh, but are you sure it is 100% secure? No, I mean, everybody knows even the FBA web page was hacked. I mean, we are like we are just an arbitration institute, and our possibilities are limited. But nevertheless, we arrange a contract with a very sophisticated company. In fact, they do defense industry work, and we hired a program that developed for these purposes with a very high security. But it is not my specialty. I mean, if you ask how secure it is, mathematically, if it is possible to hack, I cannot give the answer. I think nobody can give the answer, because the hackers are, it's like crazy, you know, they are genius. They are not normal thievery, etc. So therefore, we do our best, but cyber security is another issue. But still, we already contracted with a company that deals with the defense industry, just to secure our online hearings and online meetings. Last but not least, just before this pandemic, as Istanbul Arbitration Center, we had a very, very important project that is MEDAR, Mediation and Arbitration. In Turkey, mediation became very, very frequently used and very successful. I have to be very frank, because there was a law in Turkey providing the compulsory mediation, and therefore the numbers of the mediation may be number 1 or 2 in the world. So this is really very, very important. And for the commercial cases, now the mediation is compulsory as well. Now what we are doing in Istanbul Arbitration Center is we are combining mediation and arbitration. This is a very important project, and this is going to improve arbitration in Turkey significantly. And we are cooperating with the mediation centers in Turkey. And we are hoping, I mean, we took this challenging period just to focus on this project. And after the second half of the June, we are going to start disclosing our progress, and we are extremely excited about our new project, so-called MEDARB, and we attract incredible attention, incredible support from the mediators. So hopefully in our next meeting, I can give you statistically more figures about MED arbitration in Turkey. Thank you very much. I don't want to take too much time of you, but if there is any question, I'm more than happy to answer. Thank you very much.
Well, thank you so much, Professor AKINCI, for your excellent presentation. It is always very interesting to observe and listen the practices of international arbitration, let's say from the kitchen. And there are many questions indeed, but I don't know if you can see them. But for the participants, we have many participants in the meantime. Just you can write your questions from Q&A section. So at the end of program, we will be very happy to answer the questions from the first hand. Well, I'm very grateful for the explanation regarding the development of international technologies in terms of implementation of the arbitration proceedings. So let's observe ICC and CAM cases, what's going on with ICC. Maria Beatrice DELI, professor, she's a very close friend of mine, and I'm always happy to collaborate with Maria and Giacomo. Indeed, Giacomo was visited us last year for ILIDA arbitration certificate program. So in terms of ICC, I think everybody knows very well. It's set up in 1923, so which means that oldest maybe institution in international scheme, and they are dealing with high value of cases. Their approximate case values are over $1 million. So now the stage is for Maria Beatrice DELI. In the meantime, we have a presentation about the short bios of the speakers. However, I'm not very good with the technology, so we will send this presentation to all the participants via email. Maria, the stage is for you.
Thank you so much, Arzu. Well, first of all, I wish to thank you, Arzu, as president of ILIDA and as a colleague and friend for organizing this event. We are very grateful, and for me, it's the first time with these Turkish institutions, and furthermore, I'm very honored to share the panel with Professor AKINCI, the president of ISTAC. It's also a great pleasure, also to share some thoughts on these difficult months we have experienced. And as you know, Italy has been severely hit by the COVID-19, so and also Central Europe. So we had to face some difficulties, I would say, really from the beginning. And that is why we thought we could share also between ICC practice and the Milan Chamber some basic points as a sort of timeline that I wish to share with you.
So,
okay, here we are. Because we thought that this could be of a certain help in trying to understand all the initiatives taken by these two arbitral institutions. As you might recall, but of course, some dates are still uncertain, and there is a lot of criticism as to the the right moment in which the pandemic started, but at the end of December, we had the identification of a new coronavirus in Wuhan, in China. And exactly 1 month later, at the end of January, the WHO Director General declared that the novel coronavirus outbreak was a public health emergency of international concern. Then only a couple, three weeks later, in Italy, we had the first case, and the first case was in northern Italy, in the Lombardia, so in the region around Milan. And so in a second, Milan became the second biggest cluster of the novel coronavirus in the world. So after Wuhan and China, we had Milan. And only a couple of weeks later, the COVID-19 was characterized as a pandemic by the WHO Director General. So things were extremely complicated at the very moment, especially in Italy, and I would say in northern Italy, and more specifically in Milan.
Yes, so as mentioned before, we will share the presentation so we don't have to repeat what is in common ground between ICC and the Milan Chamber. So the fact that Milan was the center of the pandemic before other main cities, it is worth to look at what was the Milan Chamber reaction first. So in February 25, there was the first communication by the Milan Chamber, which basically postponed all the pending hearings unless parties and tribunals agree otherwise. So the default rule applied by the Milan Chamber as a first reaction was the suspension of the proceedings, but this what is important to take into account is again the fact that Milan was really in the middle of the crisis compared to other places in Europe. Then again, in March 12, there was a new communication arriving from the Milan Chamber with a new postponement of hearing and suspension of all procedural terms, including the term for issuing the final award, which was every term was extended until May 11, and that followed the same day that the government pointed out for course proceedings. So basically the suspension and postponement of terms in the Milan Chamber followed the ones in court. But again, parties and tribunals were encouraged by the Milan Chamber to take all possible measures in order to avoid undue delays in the procedures. And during the 2 months basically of lockdown, I am still sitting as arbitrator in 2 Milan Chamber cases, so I can share my own experience. So in one arbitration, we were able in any case to constitute the arbitral tribunal with a hearing with all the parties and the co-arbitrators, and to decide and set the first procedural order. So no matter the lockdown, through obviously video conference, we were able to start the arbitration proceedings. In a second case, which was at a more advanced stage, the suspension of the procedural terms came into play, and parties decided to postpone the hearing, and we just held the hearing through video conference last week. So I can say that we suffer some delay, but not too much delay.
And so if you can consider that the situation became more and more serious in Milan at the end of February, the situation was a bit different in Paris, where the Court of Arbitration is located. And in fact, what we see is that the first public initiative taken by the ICC Court dates 17 March, so 3 weeks later. And with that indication, the court postponed or cancelled all the hearings and meetings until 13th of April. So the situation was still not very clear. And at that moment, you might recall that Paris was considered not at the center of the big crisis, the pandemic. But of course, the arbitral institutions, as it was clearly indicated by Professor AKINCI, arbitral institutions had a chance to react in a very rapid and efficient way, I would say. And this is why at the beginning of April, and we were still in the middle of the crisis, ICC issued a guidance note on possible measures aimed at mitigating the effects of the COVID-19 pandemic. The impression I had from my point of view as representing the ICC in Italy was that many arbitrators and users of arbitration were not completely certain of what to do. So I thought that the guidance note published by the ICC represented a real great help for the users. And then we had later a joint statement by arbitral institutions, and there was a sort of strong cooperation among them, where the core declaration is that the ambition of the institutions was to support international arbitration ability to contribute to stability and enforceability in a very unstable environment, and so ensuring that pending cases might continue and that parties may have their cases heard without undue delay. So the basic principles that Professor AKINCI also underlined were at the center of this declaration. And so what do we see? We see that there is a different situation, a different panorama, because in that very moment we had a new overarching necessity. Because first of all, we had the need, the institutions had the need to safeguarding their staff members. And so we started, but already somewhere already in March, they started with working from home. And so the main task was to safeguard the staff members, the parties, and the arbitrators' health. Of course, the difficult situation might lead to, indefinite delays, continuous delays in the arbitral procedures, so as to nullify the efficiency of arbitration. But on the other side, this difficult situation, this crisis situation determined by the pandemic, was also an opportunity. An opportunity, maybe exactly in terms of time and money and containment of costs. Because in a way or the other, the parties and tribunals were altogether compelled to increase the efficiency of the proceedings. And in that way, also considering what was foreseen in the guidelines, they had a possibility to cope with the disputes in a more efficient way, even considering, the possibility of rendering partial awards or settling some issues which were just collateral to the dispute. And so the idea was to keep this safeguarding interest, but at the same time go on with the, as Professor AKINCI stressed, continue activity, and bearing in mind the right of the parties to be heard and obviously to fully present their case. So in consideration of the due process principle. And what we can say now, we are at the beginning of June, so a few months later, probably international arbitration showed its first and most important characteristic. So really international arbitration proved to be flexible. We've been always presenting international arbitration as an efficient method for settling disputes, for solving disputes, and a time efficient method, and also flexible. And probably during this pandemic, flexibility of international arbitration gave its best. So we also had a strong support from all arbitral institutions, and I also think that I do agree with what Professor AKINCI said. It was extremely important what the institutions could do in this situation. They could offer great service to users, to parties, and also to arbitrators. A very strong and continuous support, even if they were working maybe from home. They were organizing, trying to help arbitral tribunals to organize virtual hearings and so on. And then one last issue, in my view, is also the adaptability of the arbitral rules. We had a feeling that the rules of arbitrations provided by all those great arbitral institutions were extremely useful in dealing with this crisis situations. And even now, you might be aware that there is a reform of ICC rules going on. And exactly in these days, the ICC court is trying to consider new rules which could be, could improve the use of international arbitration, also taking into consideration in a more clear way the event of a pandemic, which was something extremely extremely serious for all of us. So what is the situation now? And according to the two initiatives published by the two documents published by the ICC in March 1st, which was a very synthetical element, and also the communication issued on the 9th of April. Well, as Professor AKINCI described for ISTAC, all new requests for arbitration had to be filed in electronic form. So no more paper, no more submission in paper. So all the documents were electronic, including also the evidentiary submissions. And then as to the typical phase in the ICC proceeding, the terms of reference or the case management conference. Well, actually, as you well know, case management conference was already held very often through a telephone. So, I mean, there was already the habit for all the international arbitration users to make use of case management conference by telephone calls. So that method was expanded in a way or the other, and according to a sort of what we thought could be considered a sort of unwritten rule, they were signed and held virtually, but this was already possible unless the parties, of course, or the tribunal agreed otherwise. And the major point is, of course, the hearings, and then probably we will discuss this with Giacomo in a broader way. And of course, in the note, in the ICC note, it was suggested to have virtual hearings instead of physical hearings. And of course, in case the parties or the arbitral tribunal decided to have some physical hearings, all the rules for this sort of meetings have to be respected, and so social distancing, and so disinfectant and whatever. But the note strongly supports the possibility of holding virtual hearings, of course considering each and every case. As to the deliberation, so the final phase after the proceeding has been closed, well, the deliberation, of course, it's quite easy to be developed in virtually, and it often happens that within the arbitral tribunal that the arbitrators share different topics, or they have an exchange of draft award within them, or they exchange previous documents. Of course, the basic principle which has to be maintained is the arbitral collegiality, and then the deliberation has to come from the arbitral tribunal considered as a whole, as a unit. And probably there are many possibilities even to maintain and to respect this principle of arbitral collegiality through virtual meetings. And then the last point, so the closing of the arbitral procedure, the awards. And the awards, according to the note, and this was made for many other institutions, awards can be signed in electronic form and circulated through email. So some new methods, but also an extension of methods which were already provided for in the arbitral rules.
Well, with regard to the Milan Chamber, the situation is not much different. The important piece of information is that from May 12, all terms resumed, so there are no more suspension in place, but still the new request for arbitration must be filed in electronic form, and this obviously is in order to help maintaining all the social distancing rules that are still in place in the country, and that also affect the hearings, where the Milan Chamber is, I would say, strongly encouraging parties and tribunals to hold the hearings virtually. This is not mandatory, of course. It is left to the will of the parties, or the decision, as we will see later, of the arbitral tribunal. But the suggestion of the Milan Chamber is to use technology at this stage. One important element, maybe of difference between the two institutions, is that the Milan Chamber provides a quite unique service, because at every hearing you have with the Milan Chamber, you normally have a member of the Secretariat that is present, is physically present, helping the arbitrators, helping the counsel to, in order for the hearing to go on smoothly. So now, in this current situation, of course, the member of the Secretariat of the Milan Chamber cannot be there with you, but is still participating to the hearing virtually, still there organizing the virtual hearing, providing the support with the minutes, And this doesn't happen with the ICC typical arbitration hearing, where counsel and arbitrators are basically left to themselves. They don't have this kind of support that the Milan Chamber normally provides.
Giacomo, sorry, indeed, it is a very interesting point that you are mentioning. It is very impressive by CAM, Milan Chamber of Arbitration, to observe during the hearing. The case managers are attending so much attention. And after your presentations, I will ask also, there are some questions as well. I will ask to Professor AKINCI how the hearings works in ISTAC as well, before and after COVID-19. Just continue, thank you.
Sure, thank you, Arzu.
Well, so, I mean, the core issue is the virtual hearings. This is something maybe still new for many users of arbitration. And probably even if some of you might recall the Seoul Protocol on video conferencing in international arbitration, which was largely mentioned in the last weeks. But the Seoul Protocol, actually, it is not, it was signed, was prepared in 2018, so 2 years ago, when there was no need, no pandemic, no emergency. But still it represents a good reference for organizing the techniques and technicalities, which I would say there are some techniques and some technicalities which goes around the holding a virtual hearings. Of course, I just pointed some of the issues, the elements which have to be considered. First of all, a very technical point, the choice of a good video conference platform. And this is, I mean, we all have experienced different platforms during the last weeks, and we are probably more digital than we were before. But of course, a good video conference platform means that we should also identify a system which responds to the needs of arbitration. So either the need to keep from the point of view of the arbitral tribunal to have a full view of the virtual rooms, it is something extremely important to take into consideration. It's also important for the arbitral tribunal to be also to really be confident and trust the virtual procedure, to verify the presence of all participants, and the participants have to be duly identified, and maybe sometimes the arbitral tribunal might allow, you know, counsel and parties to be in the same location together, or maybe not, depending on the case. So this is something that the arbitral tribunal will have to establish. And then, of course, during every big arbitral procedure, we make use of transcript. And of course, the real-time transcript seems to be important, even in virtual hearings, and this is the same for simultaneous interpreters. But we probably have something new, which is the possibility to record the hearing. And, you know, having the hearing recorded means that either the arbitral tribunal members or the parties might just review what has happened during the procedure and maybe try to understand better, or try to catch some expressions, even those expression and mimics, as Professor AKINCI was mentioning before. This could be a new instrument for having a more complete awareness of the hearing. Of course, as we can see today, we have to share our screen, and this has to be perfect. So all the presentations by the parties should be full shared thanks to visual aids. And probably it is also useful sometimes to organize a test just to try to especially in big arbitrations where we have many parties, we have a lot of components in the as counsel. This could be extremely useful. So without having, let's say, mock hearings, but maybe a test could be useful. Then, of course, apart from the technicalities, maybe there are some more important techniques, let's say. So we have to stress the importance of a full control of the hearing by the arbitral tribunal. And then, as already stressed, an issue of confidentiality, of privacy and security. And probably it could be also welcome the introduction by an arbitral institution of a system for video conferencing, which has all those, all those elements, all those requirements are met in order to guarantee confidentiality and security. But as Professor AKINCI already stressed, these are things that probably we will obtain in the very next future. And ICC in the guide published in the guide notes published in April also suggested the inclusion of a cyber protocol into the hearings procedural order. I think this is a possibility which is extremely I mean, it's a possibility. Sometimes it could be controversial in case one of the parties doesn't want really to accept or wants to, put in place some guerrilla tactics, and so they might refuse to accept to sign a cyber protocol in the form of an agreement. And another issue I wanted to point out, which is the rules of arbitration now in force in the ICC, is the procedure for the taking of evidence. And I wish I could, I'd like to read the point, Article 25, number 1 of the ICC rules, which provides that the arbitral tribunal shall proceed within as short a time as possible to establish the fact of the case by all appropriate means. I think this is extremely useful, it's really instrumental for opening to virtual hearings, and so to the possibility for the arbitral tribunal for taking evidence even through some virtual methods, from video conference and other transmission. Another reference is of course given also to the report, which is not which was published a couple of years ago, report on the use of information technology in international arbitration.
Okay, so moving forward, we consider that now, as was also pointed out by Professor AKINCI before, the main issue and the main theoretical issue, not only practical but also theoretical issue, is whether there is or not a right to a physical hearing. What happens in case one of the party wants to move forward and to hold a virtual hearing, but the other party objects because the other party expects to have a full physical, old-style hearing? So we think this issue must be analyzed in two different scenarios. One is the scenario under the current emergency until restrictive measures are in place, where there is not really an alternative, so you cannot but have a virtual hearing. So refusing to have a virtual hearing may risk to postpone indefinitely an arbitral proceedings. But the second scenario, maybe the more interesting one, is when all this will be over, but we will still have parties that will suggest or will prefer to have a virtual hearing when it makes sense to have one. And so what if there is a split between the parties? One wants to have a virtual hearing and the other one wants to have a physical hearing. So again, the question is, does in arbitration exist a right to a physical hearing or not in case of disagreement between the parties? So to answer this rather complex question, I think we have to look mostly at mainly at arbitration rules on the one hand, and on the other hand, the lex arbitri, so the law, the civil procedure law that the arbitrators have to apply according to the seat of arbitration. So if we look at the ICC rules, we do not find an answer to this question. We can only find some indexes, some indicia in the rules that may give us some possible suggestion for an answer. So the most important is Article 22, where we find the two fundamental principles that were also mentioned before by Professor AKINCI. On the one hand, the arbitrators must make sure that the proceeding is expeditious and cost effective, and this is Article 22.1, but then also they have to make sure that each party has a reasonable opportunity to present its case. So you can immediately see that there is a balance here to be reached by the arbitral tribunal. The next important principle is that the arbitral tribunal normally enjoys, and this is also true under the ICC rules, a quite wide procedural discretion. In case there is no agreement between the parties, it is normally up to the tribunal to decide what are the most appropriate procedural rules. Then we can also look at Article 24.4 with regard to the case management conference. There is an express provision saying that in the absence of an agreement of the parties, the arbitral tribunal shall determine the means by which the conference will be conducted. So you can see here that the scenario where there is no agreement is expressly regulated only for the case management conference, not for the hearing on the merits or for the taking of evidence. So we can interpret this rule in two opposite ways. On the one hand, we can say where there is a favor for flexibility, a favor for allowing other means. On the other hand, someone may argue, well, if this possibility for the arbitral tribunal to depart from the physical hearing was provided by the ICC rules, this would have been done expressly, as the ICC did for the case management conference. So you can use this rule to argue both ways, basically, in my opinion. Then we can look also at Article 2025, which says that the arbitral tribunal may decide the case solely on the documents submitted by the parties unless any of the party requests a hearing. So there is expressly a provision for a right to a hearing, but does it translate into a right to a physical hearing? Does it mean that the right is to having a hearing in person, or just a hearing no matter what are the means through the hearing is conducted? And if we look at the report on techniques for controlling time and cost published by the ICC, I think the last version was in 2017, we have a couple of provisions that support the possibility of having hearings not in person but virtually. That is not conclusive. That does not mean that the arbitral tribunal definitely enjoy discretion in deciding how to hold the hearing, but again, it is a possible, these are possible provisions to look at. And finally, there is obviously a rule that specifically regulates an ICC hearing, which says that the arbitral tribunal basically shall summon the parties to appear before it on the day and at the place fixed by it. So can we interpret the term place as including also a virtual place? So here clearly is the tribunal deciding the place for the hearing. Does it mean that the place can be interpreted and understood as a Zoom platform or other technological platforms instead of a city, instead of Milan, Paris, or London? This is obviously an open question. So as you see, we can find some possible suggestions in the ICC rules, but not a conclusive answer to this question. If we look at the CAM rules, I think we have a provision. At Article 2, we have the same basic principle, due process on the one hand, and on the other, flexibility, procedural discretion in the hand of the arbitral tribunal. But then if we look at Article 27.2, we see that the arbitral tribunal may grant the attendance of the hearing by any appropriate means. This is a much clearer expression compared to all the ones we have analyzed before in the ICC rules. There is no doubt, in my opinion, under the CAM rules that the arbitral tribunal can decide, in case there is no agreement between the parties, to hold a virtual hearing. I am actually experiencing this firsthand. We have a case where the two parties do not agree on what is the best way of holding a hearing, and the decision will be up to the arbitral tribunal eventually. Then we have to also look at the lex arbitri. We have to see whether there is in the country where the arbitrators are sitting a mandatory provision requiring for a hearing in person. In case there is that provision, I think the arbitrators must be very careful not to have a physical hearing when one party requests to have one. So very important to look at the lex arbitri. If the lex arbitri is silent, then most probably the default rule is that everything that is not expressly prohibited is permissible, is allowed. But again, we, as arbitrators, you have to be very careful when you decide for a virtual hearing and there is no agreement among the parties, because you want to make sure that the award is later enforceable. To summarize this very delicate issue, here you can read 5 questions that I can maybe leave it here for the sake of time, but Arzu, you can share our presentation to the participants later, and this question may be used as a sort of guide for answering this complicated question. Now, the next point.
The next point we wanted to raise is identifying the question we wrote in the slide. Necessity turned into opportunity, question mark. This is the question. So if we consider what has happened, first of all, I think we cannot but note that we were shocked by the pandemic. We didn't know what to do. We didn't know what was going on. It was really serious or not. This was the impression in Italy, at least. So the first reaction was certainly to delay the activity, and sometimes the activity was suspended. Then we had a second step, a second reaction, and in a way or the other, we thought that we had to go on, we had to proceed, and so we attempted to recreate the same environment we were used to have in the physical world, in the virtual world. So in a way, we wanted to try to test the virtual possibility to hold virtual hearings, to see if it was exactly the same as we had in the physical, what we were used to have first. And then a third reaction, which is an improvement, of course, and we started to adapt to this new scenario and also be more confident, probably, in dealing with this virtual world. And so the arbitral institutions, after a first moment in which they tried to defend the practice, tried to keep up and provide new rules. And at the same time, what we witnessed was a very diffused and rapid digitalization among parties and arbitrators. So really we had a step-by-step a change in the last 3 months, let's say.
Yes, and I think this slide requires a bit of explanation. Here you see two jars. One, of course, is the well-known Nutella, that this image can be considered the old style and the prime service provided by arbitral institution. Let's say the physical hearing in a nice ICC hearing conference room. And on the other hand, you have a new product, which is a sort, if you want, of a subprime, not the well-known prime quality product, that we were forced basically to use during these 2 months. So the interesting thing is that we were used to buy Nutella because that was the only product that we were considering in the market, but all in a sudden we were forced to switch to something different, which is the virtual hearing, a different animal in arbitration. So we have to consume, basically without no choice, a new product that we can consider sort of subprime, less good, because as Professor AKINCI was mentioning before, we may lose something during the cross-examination, the mimics, the control by the arbitrators of the hearing room, etc. Now the question is, once this is over, we will still have possibly these two products in front of us. And so are we sure that everyone is going to go back to Nutella instead of keep buying the subprime product once we have discovered that this product is not so bad, that this product may offer some very convenient features and all the saving costs that we have been discussing? Think about the fact that the parties do not have to pay for travel expenses, hotel rooms, hearing arbitration rules fees, and all the hour that lawyers charge when they have to travel abroad, and so on and so forth. So most probably in the future, we will have two new ways of conducting arbitration, and it will be very interesting to see what share of the market will be occupied by the Nutella jar, to use my image, and which share of the market will buy instead and will keep buying and consuming the new product that we are consuming during these days. And the last point of our joint presentation, so don't worry, we are close to an end, is what are the arbitral institutions, and of course we're very curious to hear from Professor AKINCI's perspective, what are they expecting? Most probably they are expecting a sort of wave of tsunami of new arbitration claims, because we all know that there is in these days a hot topic that everyone is discussing, which is a sort of a massive breach of contract because of either force majeure or hardship that was caused by the COVID-19 pandemic. And we can show you some numbers. Okay, so basically, if we look at what happened in China, the China Council for the Promotion of International Trade has issued more of 7,000 so-called force majeure certificates, meaning companies going before this Chamber of Commerce in order to obtain a certificate saying that there was a situation of force majeure going on. In order to show and present this certificate to the other party in the moment you send the notice, the notification of force majeure. Now, these certificates and this data is only updated up to April 20, covers an amount, total amount of more than $98 billion. And the situation in Italy is also interesting.
It's also interesting. So you can see in this slide that this is the situation only in April 2020. So the declarations on force majeure, which have been released by the Chambers of Commerce after a communication of the Italian Ministry for Economic Development. And this certification, as you can see, it's a huge number. In 1 month, we had 1,311 documents issued, with a number of companies asking for the certification were 1,000. And so this is, the certification we had, and you can see that at the end, the last sentence is, the above-mentioned company stated that in relation to the restriction imposed on the state of emergency in progress, it was unable to fulfill the contractual obligations previously assumed due to unpredictable reasons, independent of the company's will and ability. So we have a large number. We will only give you the data, on the Italian side for April. So we assume, we are brought to think that the number will increase. It has increased in May and probably in June.
Yes, and I think that one very interesting point is to understand the legal value of these certificates. This will be very much litigated in arbitration, and so it will be interesting to see how many of these certificates, force majeure certificates, will bring to arbitrations. These are just closing remarks. We, of course, now will, as counsel, now let's switch for a moment heads. What we are seeing is that the companies are in a phase where they are struggling in deciding what is the best course of action, whether to settle or litigate. We had the opportunity to discuss this issue with a major Italian multinational, which received more than 400 notices of force majeure from their partners around the world. So you can imagine that starting 400 arbitrations at the same time is not doable, it's not feasible. Yes, so
it is impossible.
Sorry?
Yeah, it's almost impossible, and we are just last 2 minutes maybe, Giacomo, to conclude.
Yes, that was the very final remark, Arzu. So that was just to leave an open question, and well, before closing, I want to, of course, we didn't say at the beginning, to thank you and Professor AKINCI for this joint opportunity, and we are, of course, happy now to answer any question.
Thank you so much, Giacomo and Maria Beatrice, for your presentations. I would like to say something about Nutella. 80% of the nuts are coming from Turkey to Italy. So you're producing Nutella with the Turkish nuts, so which is an important issue for international arbitration as well. And in the meantime,
Nutella because of the Turkish nuts.
In the meantime, we received many questions regarding especially the implementation of MedArb rules. Professor AKINCI, could you please kindly explain us this MedArb procedures in a brief way, please? Thank you.
Thank you very much. With a great pleasure. Well, before I start, I just would like to thank to my colleagues for the excellent presentations. I learned a lot personally. I'm sure all the participants enjoyed it. Thank you very much for the very useful and clear explanations. Well, MEDARP is our new baby and we are very proud of it. In a nutshell, talking about Nutella, in a nutshell, I would like to talk about MEDARP. Well, we have two main targets. First, as Arbitration Institute, of course, we promote the business people to insert an arbitration clause in their contract. But now we promote MEDARP clause as well as arbitration clause, of course, but we are just promoting the concept MEDARP because if they have MEDARP clause in their contract, they can have mediation that is extremely efficient, very fast, very cheap, and very peaceable. But if it works, so if the parties settle, then it is just like national lotteries. Suddenly, within a couple of days, you can settle the dispute, you can save time, you can save money, and it will be very civilized, very peaceful, happy end for the parties. But unfortunately, especially in the commercial disputes, parties may not settle all the time. So if this is the case, this mediation concept, this package includes a binding resolution as well. If the parties cannot settle the dispute, then the arbitration starts. And especially for the domestic arbitration, we have incredible time records. So they can resolve the dispute within a very short time and also very economic, in a very economic terms. So therefore, the first target is to introduce the concept of MEDARP clauses to the commercial contract. And our second target is, I was mentioning about compulsory mediation for the commercial cases in Turkey. So this is a great opportunity for us because now we are in cooperation with the mediators. And the mediators, when they try to settle the parties, if they settle, the dispute is going to be settled. But if not, they are going to enlighten the parties saying that, look, you could not settle, unfortunately, but be aware, you don't have to go to the court. There is a possibility to resolve your dispute through arbitration in ISTAC. And they are going to give explanation, and if necessary, they are going to assist the parties to draft the arbitration clause. And by doing so, even the contracts don't have arbitration clause, ISTAC arbitration clause, the dispute can be referred to arbitration instead of the court. So those are our two main targets. And we are in cooperation with, of course, the lawyers, attorneys, and business people, as well as the mediators in Turkey. And we are very optimistic, we are very eager on this project. I hope this explains. One more thing, of course, the main question academically and practically, can or is the same person going to act as mediator and arbitrator? The answer principally is no.
No.
The mediator is going to be one individual, and then if there is no settlement, then ISTAC is going to appoint the arbitrator. It is good for the mediation, and it is good for the arbitration as well. However, if the parties, both of them, agree that we want this mediator to continue as an arbitrator, we want written consent from both parties. And if this is the case, the mediator can act as an arbitrator.
Thank you so much, Professor AKINCI, for your detailed explanation. Giacomo and Maria, could you briefly explain us, do you have any comment on MEDARB system and how is it in CAM, Milan Chamber of Arbitration, and ICC, the similarities, controversial positions, etc.? Can you just briefly explain us, please?
Well, as for the arbitration rules and mediation rules, you might recall that they were, at first, they were all together in one booklet. And then they decided to separate because both procedures, proceedings that were diversified and improved a lot, increased a lot. And actually, the basic principle is the same, which has been illustrated by Professor AKINCI. I would say that maybe mediation, ICC mediation, it is not so well known as arbitration. So we have to be, I think we have to be realistic and truth, and ICC is generally understood as an institution for arbitration, but still ICC mediation is extremely well considered, but of course less cases. What I can add is that apart from the dispute boards, but the expert rules from the ICC are starting to have I don't know, maybe a new life in a way. At first they were confined to some very technical sectors, but in the last 2 months, surprisingly, the ICC Italian committee, I was called by some users, 2 different users who wanted to enact the expert rules. So I thought that could be an interesting consequence of the pandemic.
Mm-hmm. Thank you. Giacomo?
Yes, if I can add something with regard to the Milan Chamber. Well, in Italy, we have a similar system where the mediation is compulsory for many different types of litigation. So the Milan Chamber has a very strong practice in mediation, which is separate from arbitration. Also because in Italy, we have a strong feeling that you cannot decide as an arbitrator after you have acted as a mediator, as Professor AKINCI was suggesting, so differently from other legal systems such as Germany or Switzerland, where you can have both heads. What is interesting of the Milan Chamber practice, though, is that normally after the exchange of the briefs, there is a hearing with the only purpose of trying to settle the case. Now, what is complicated is how to interpret your role as an arbitrator at that hearing, because again, the purpose of the hearing is to try for the parties to reach a settlement, but still you don't have to act as a mediator. You don't want to tell the parties too much about your thoughts, otherwise that will jeopardize your independence and impartiality for the rest of the proceedings. So it is a sort of interesting because it's very common in the CAM arbitration to have this hearing, and I think the reason is that we do have that in front of Italian judges, so it's sort of a replication of what happens in court. But then as an arbitrator, it's tricky because you have to be very careful in handling that settlement hearing when you are as arbitrator.
Thank you so much, Giacomo. In fact, Milan Chamber of Arbitration was doing very well during this pandemic process as well. We have 2 pending cases, and they handled very well the cases with the case management team. And it was an interesting experience to have a look how the institutions are reacted, because of course, Milan was the capital, kind of European capital of this COVID-19, and it affected in a very deep way. However, as you mentioned during your presentation, some other cities like Paris, like Istanbul, affected from COVID-19 in a less level. So it's also shaping the international arbitration proceedings. Well, there is an interesting question about the video conference practices of ISTAC. If it would be limited with the COVID-19 pandemic period, or these measures are to stay in arbitration practice of ISTAC as well. So if the measures will be temporary or will continue afterwards, Professor AKINCI.
Well, it is very difficult to predict, but what I can say is there are definitely two moral from this pandemic period. Well, first of all, I think we all are very open-minded. Nobody is going to be prejudiced saying that, oh no, it is impossible, I'm not having this, etc. So we all experience, and at least to a certain extent, it works. And second, for some cases, it may be especially very, very efficient, especially for the small cases. I mean, before the pandemic, I had some video, at least partly video conferences, because the witnesses could not come to the place of arbitration because of some legal issues. So therefore, for this kind of necessities, it is efficient. And imagine for a small cases, or imagine if there is going to be another problem, there may be restriction with the travel, etc. So now we all know it is doable. We all experience it, and at least we are open-minded. And I think nobody is absolutely against it. The question is, if it is not the emergency, but it is only alternative, would the parties prefer it? For complex arbitration cases, my humble opinion is, I think still many of the counsels would prefer physical hearings for many reasons. I mean, it is quite understandable cross-examination of the fact witnesses, experts, and also for the attorneys, just following up the arbitrators, the electricity, this is very, very important. And I mean, when we have this kind of online communication, we look at the camera, but in the physical meeting, we have the eye contact, we can feel it, and of course it is different. So I cannot say now it is over, physical hearings are over, now this is the new area. I think it is too early for this. Once people think it is available and not too difficult, I think for some cases definitely people are going to prefer physical hearings. But one thing, one benefit from this challenging period is we all accepted that there is an alternative and we are open-minded.
Yes, it was a really interesting experience to try to handle all the cases by using technological opportunities. And indeed, there is an interesting question. What about the following clause? The seat of arbitration will be, for example, ICC or ICC, but the entire procedure will be concluded online. Maria Beatrice and Giacomo, what do you think?
Well, I think that the provision for the seat of the arbitration will be limited to its legal value. So it's no more, eventually we have a provision which states for what it was made for. So it's legal, juridical meaning and not the geographical location. So I think that will be the, I mean, even if held in virtually, we will keep the provision, the indication of the seat as a legal matter.
Yes, no, of course, because then you need to know which nationality the award will have. So in which, for example, Court of Appeal, you have to eventually try to set aside the award. So you still need to identify a seat of the arbitration, even if you never meet in person. So, yeah.
Thank you, Giacomo and Maria Beatrice. And do you have any artificial intelligence technologies that are using for the arbitration in any institution, in ISTAC, CAM, or ICC? Professor AKINCI?
Yes, we initiated the artificial intelligence issue that we initiated was drafting the arbitration clause. We already have a sample arbitration clause in our website, and I mean, it asks you questions. I mean, like place of arbitration, number of arbitrators, etc. And it guides you to have the tailor-made arbitration clause if you want to improve or change the default arbitration clause of ISTAC. Now we would like to make it as an artificial intelligence arbitration clause. So that means this algorithm is going to offer the best, after asking some questions, it is going to offer the tailor-made best arbitration clause to the practitioners. That was one project. And another project, we had a meeting, it was about drafting the statement, and it was a little bit scary, I have to say. So we did not continue this because I mean it is unbelievable. It just simply on the PDF format review the submission, and then I try to identify the relevant cases and offer the relevant cases for each paragraph. And the more you use it, it learns what is going to be the relevant answer and you know, related cases for this. So maybe I said we should not be part of this project, at least for time being, ethically. But for the arbitration clause drafting one, yes, we initiated it, and hopefully we are going to finish it soon.
Oh, thank you so much, Professor AKINCI. In the meantime, there are some questions about statistics of ISTAC cases. How many cases do you handle during, or approximately in 1 year, and how long does it take? Could you kindly explain us briefly the statistics?
Yes, I'm not very good with the numbers, but I can give the information as far as I have. Normally, our statistics are disclosed at the end of the year. We had, if I am correct, 57 cases, and normally under our rules, the case should be completed within 6 months. And if it is fast-track arbitration, the case needs to be completed within 3 months. This may be shorter, this may sound shorter than comparing to the other rules, but in Turkish practice, Arzu Hanım, you may be familiar, in commercial courts, we don't have the tradition of having too many witnesses. So therefore, it is very efficient, and I'm very happy to say all our fast-track arbitration cases have been completed within 3 months. That is really very, very big success for the parties and arbitrators. And generally 6 months is the good period. We have a few cases we need to extend the time, especially construction and energy cases. You can imagine there are some technical reports, experts reports, etc. It takes time. But the parties are very eager to conduct the arbitration very efficiently, and also the arbitrators. So the period of the arbitration cases is really very impressive.
Okay, thank you so much, Professor AKINCI. There is a question about scrutiny. Maria Beatrice, the question is for you. Normally, it is a typical procedure for ICC proceeding. Could you kindly explain us the scrutiny after ICC awards? And they are also asking if do you have any scrutiny after ISTAC awards, Professor AKINCI?
Well, scrutiny, can you hear me?
Yes, yes.
Oh, okay. Well, scrutiny is a typical phase of the ICC procedure, and it comes when at the end of the deliberation by the arbitral award, the tribunal sends the draft award to the court. And what I can say is that it's supposed to be a formal scrutiny, not certainly on the merits of the case. But it's always, conducted in a very careful way in order to avoid all those little issues which could be related to even some linguistic problems sometimes. And, also in order to consent that the award is coherent and it's complete and all the issues have been coped with by the arbitrators. So it is something which seems to be kept. And if I can just answer with regard to the artificial intelligence, I think probably ICC and also the Milan Chamber are still far from accepting the artificial intelligence as applied for the appointment of arbitration cases, ordinary arbitration cases, while the ODR seems to have an increasing relevance, especially for certain sectors of disputes. So.
Thank you so much. Professor AKINCI?
Scrutiny is really a very interesting process. Well, first of all, not all the international institutes have scrutiny, and most of the time the regional institutes don't have the scrutiny process. ICC traditionally has scrutiny process, and traditionally ICC has been extremely successful in this issue. I acted as a court member in ICC for many years, and I observed the quality of the contributions and the time that the world famous arbitration expert allocated to scrutinize the awards, and the council work just to improve the quality of the award. It is fascinating. It is really very, very good. But having said this, would it be good for all the regional institutes? This is another question. ICC has been doing it very successfully, but ICC is, traditionally different than the institute like us. If you have a scrutiny in ISTAC, so that means, first of all, that requires more counsel, more staff. So it is going to make arbitration more expensive. And in ICC, because it is an international institute, it's like United Nations, anyone who is invited to the court, very willing to participate and work for ICC. This is a big issue, of course. But people spend so much time for this. Can you manage such an international community? This is another challenging point. And the last, ICC is again like United Nations, it is international, but if you would like to have such a scrutiny process in a regional institute, the participants, the parties may have some prejudice. They say, okay, the arbitrators are going to decide, but suddenly in the administration body, they are going to say, please change it. So people may not be as comfortable as they are, and also it may be interpreted differently by the national courts. So therefore, scrutiny is very good for ICC, and ICC has been extremely successful traditionally, but it cannot be the same for the regional institute. So therefore, in Istanbul Arbitration Center, we did not have scrutiny process. We have to be realistic. It increased the cost, it increased the time, because it may be some weeks, even months necessary to exchange the comments that arbitrators are going to redraft the award, etc. So therefore, for the institute like us, it is more efficient not to have the scrutiny process. But having said this, we are very proud and happy that ICC has been conducting the scrutiny process extremely successfully.
Thank you, Professor AKINCI. The last question about the Turkish government's officially declarations. Did the Turkish government officially suspend the terms for arbitral proceeding during the lockdown? More generally, there has been any measures which impacted on ongoing arbitrations in Turkey? Professor AKINCI.
Thank you, Arzanam. Well, first of all, there has been a decree and suspension time has been extended afterwards. So at the moment, until 15th of June, all the court proceedings and mediation proceedings has been suspended. So there has been a decree, but this does not include arbitration and arbitration institute. Nevertheless, all the arbitration institutes in Turkey cease their activity because of this challenging period. But as I said, we did not stop. Like they say, we are Sparta. Although it was a challenging part, they say, okay, we can continue. We are very sympathetic if they want to stop, but we should operate as much as we can. And we continued and it worked. But officially the court stopped and they are going to start after 15th of June.
Yes, correct. And thank you, Professor AKINCI and team of ISTAC for your contribution. Thank you, Giacomo and Maria Beatrice DELI for your contribution and effort of D&R Law Firm. And thanks to my team also from ILIDA. I think it was a very interesting experience to analyze 3 important international arbitration centers' practices, and we had quite a lot numbers from the different countries, the participants. It is interesting, and we should continue to organize such events, especially in terms of comparative studies. Well, I'm going to conclude. Lastly, Professor AKINCI, would you like to say something to the audience?
Well, thank you very much. It was very, very interesting to participate, to learn from my colleagues, from the professors. And thank you very much, Arzana, for this excellent organization. And for the audience, thank you for their patience, of course. Thank you.
Maria Beatrice DELI and Giacomo.
And I think also on our side, a big thank. It was an honor, and we were extremely glad to share the panel, as I said, with Professor AKINCI. And thank you, Arzu, for your efforts. You did a wonderful job today, and I really hope you can organize something else. And we will be eager to have another meeting, virtual meeting as this, but maybe also in person, who knows?
Yes, I join Maria Beatrice in thanking you and ILIDA and the ISTAC. I had the pleasure 2 years ago to be at the ISTAC for a conference, and I hope that the travels will resume soon so that we can also meet in person again. And also I want to thank the participants that were so patient to listen us today. So thank you all.
Thank you. Thank you to everybody, all participants and all professors. We are looking forward to meet face-to-face in healthy days. And follow our events from our website or social media. Thanks for your time and contributions. Have a nice day.